walked into this building because I always joke to my students, having taught for longer than, next year will be 50 years, and I've, for almost all that time, I've said to my students, you know, I'm teaching you because I want, even under the gloomiest of apartheid times, I'm teaching here because actually I believe in a society based on non-racialism, non-sexism, and the rule of law under the apartheid system is always a dream. I'm not teaching you so that you, as soon as you get your law degree, you go to a fancy law firm and can acquire a Mercedes-Benz. Obviously, you're not closer to Mercedes-Benz than I dreamt that would be the case. I've been asked, obviously, I'm chairperson of the Companies Tribunal, but I can't divorce myself from the fact that for 20 odd years I was the judge president of the Competition Appeal Court and still sit there. And so I wanted, perhaps, I know you will hear about that, but I wanted to talk to you a little bit about both these issues with a particular direction in mind. Firstly, commercial law, and obviously these are commercial law areas. Commercial law, through my entire career, has been dominated by a few, and to be quite blunt about it, white men, right? Because the apartheid structure ensured that almost every single person I'm looking at this room would probably have had, under the apartheid system, extraordinary difficulty. I mean, you're an example of somebody who essentially transcended all of the absolute abuse that the apartheid system hurled at you and your fellow citizens. But it's important to remember this, because the whole point about it is, if you look at law firms today, if you look at the counsel who appear in commercial cases, and I'm referring to competition cases, I'm referring to companies cases, they are predominantly white men. So I'm delighted, firstly, that I'm talking to so many women here, no disrespect to the men. But number one, you are the future. And you have to understand something, that we will never be able to develop a profession which essentially earns the legitimacy of the population. And when I talk about the population, I'm talking about 60 odd million people, unless the profession reflects, broadly speaking, not precisely, broadly speaking, the demographics of South Africa. And so, when it comes to commercial matters, it's desperately important that a whole group of you actually rise to the challenge. And I'm going to tell you that the challenge is one moment, which is actually a lot easier to rise to than you may think, but we'll get there. But the simple proposition I wanted to start with, almost to leave you with, is how important it is that it is your generation that if in 20 years' time, you know, I may not be around, but there will be people like me who are around, and we look at the profession and it looks the same as it does now, we will be in serious poo, right? Bluntly put. So the challenge is yours. Now the curious thing about it is that in the two areas that I want to talk about, it's much easier to break in than you may think, and it's partly because of the point that you made about globalization. It's partly because in these two areas of law, dramatic changes have taken place. So the vast majority of people who rose to the top would have probably never been taught a competition course in their lives, which I might add, often reflective of the fact that the people who appear in front of me, you can actually realize just how ignorant they are. Not that they think they are, but they are. That's a secret between you and me. And in company law, we changed the Act in 2008. So there's a brand new Act. And the challenges in both of these areas are relatively fresh, which means that young, energetic people who want to make their name in an area where you don't have to be there for 50 years in order to rise to the top, these are areas which have a potential, apart from all of the other important points that I've made with regard to the transformation of the profession. Now let me try to explain more. Let's take just competition law first. You mentioned the point of the rule of law, and you're absolutely right. One of the obvious issues that we are now learning from the madness across the Atlantic from Donald Trump, right, is if you don't have the rule of law, if you have some autocratic individual who wakes up every day and changes his mind, to the extent that he has a mind, the point is eventually people start investing because they don't have any certainty. And so in these areas of commercial law, the fact that people investing in South Africa, creating jobs, and essentially broadening the imperative and inclusive growth in South Africa, do need to know that the law actually works in a way that can be predictable. So that's why we say company law and competition law, these are vital areas. Think about it. For any company seeking to invest in South Africa, both internally and externally, the two most important features are, number one, you have to know how you're going to acquire a company. You're going to merge with another company. If you invest in South Africa, you want to know that maybe the competition authorities are going to prevent you from doing so. The Companies Act has to regulate the disputes that you have. And unless these things are done with a level of certainty, trust me, what happens is people move elsewhere. And I think South Africans need to understand that elsewhere doesn't mean England and America. Elsewhere is increasingly becoming the rest of Africa. Whenever I go to other countries in Africa, Kenya, Ghana, etc., which I do quite regularly, I'm struck by just how, in a sense, these countries are growing and their infrastructure actually supports them. So we can't be sitting on our laurels. Now, to return to why these areas are now, in a sense, cutting edge and new. If you take a competition law, when I studied competition law, the fundamental proposition was what was competition law about? And here's the 101. You can go home and tell everybody at your next dinner party. They'll be very impressed with how much you know, right? What it was about was ensuring that in a market, for any good or service, the customer, the consumer, got the biggest choice of product available at the lowest possible price. You didn't want to have a market where there was only, to put bluntly, one motor car that you could buy at an astronomical price. You wanted to be able to show that, well, you know, Mercedes are going to charge you X, you can go around the corner to BMW if you like a luxury car and see how much they are, and etc. So the test was price low, lots of goods available in the market. Not unimportant. But now, competition law is particularly interested in issues of market power, the ability of firms to impose their will on all of us. And if you think about it, you know, they talk about GAFA, which is Google, Apple, Facebook and Amazon. And there are obviously a couple others now. You take them, they are so powerful today that they are wealthier than many countries. And they can impose their will. In other words, if you want an Apple iPhone, the price is X, and that's it. And what happens all the time? So you take, for example, a case in the United States at the moment. There was once upon a time, there was an app that all of you use called WhatsApp. WhatsApp was an independent company. WhatsApp was an independent company which basically developed its own innovation. And what did Meta do? They realized this could be a potential competitor. And they don't want competition, so they buy it up. And before you know it, you don't have a choice anymore, because they're the only one in the market. And what has happened? We've got levels of greater inequality in the world today than at any other time in our history. And I do not need to tell a South African audience about that. So the result is that competition law now is now moving into areas of how does it address problems of market power, which in turn reproduce systems of inequality. This is where, in other words, the field is at an inflection point. What I mean by that is the old style competition law is now being replaced by these broader questions. And people who studied it under the old system have as faint idea about these challenges as you who never studied it have. Which means you're all in the same boat. Which means if this is an area, and you were speaking about LLMs, if you're in an area, you've got an LLB degree and you want to specialize, well, there's an area that you can start specializing in. And you're not going to be competing against thousands of people who are experts already, because there aren't thousands of experts already, I can assure you. And not only that, but because you now are in a field which to a large degree is changing so dramatically, you're at that cutting edge. And that gives you kind of a professional opportunity that you probably wouldn't have had 20 years ago, even in a democratic society. So what I'm trying to say to you is, there are new challenges in this area. Obviously, you'll hear more about that in a moment. So let me then stick to my lane, which is company law. And there too, things are changing. Firstly, we have a new act. Secondly, what is the big problem about, well, one of the big problems of company law? One of the problems is it's not only big companies that are companies. There are many little companies. And the trouble about these little companies is that to a large degree they need legal representation. And to a large degree they don't get it, because if you go to the large law firms, right, the fees are so astronomical. I used to laugh, when I did some tax consultancy long, long ago before I was a judge. With one of the large law firms, I used to say to my colleagues, when the client comes in and you offer him a cappuccino, that's already costing him 5,000 rands because of the fees that are going to be charged. It's the most expensive cappuccino in the world. So what I'm trying to say is that in company law, there is a whole host of constituency out there desperately needing lawyers. And again, the Companies Act changed. It used to, when I was a student studying company law, basically we had a thing called the shareholder model, which meant that a company only was supposed to act to the benefit of its shareholders and nobody else. Today that's no longer true. Companies have obligations to their workers. Companies have obligations to the environment. Climate is not an unimportant feature. It may not be for old fuddy-duddies, but it actually is vital and vital to all our futures. So companies have an obligation. Companies have an obligation to the communities in which they're in. If you're the only company in a particular town, you have an obligation to the town. So you've got you've got an obligation to your customers. One of the things I used to always be struck by, probably true today, tried to be a small producer of food products negotiating with ShopRite, Checkers or Pick n Pay, and see the extent to which they extract as much from you as possible. So the questions are, company law no longer simply is an area of law which concerns itself only with the shareholder. Once you've moved away from that, colleagues, you've moved into a new area, and yet again, just like I'm saying about competition law, it's an area where it's an inflection point, and young people coming in have as good a chance of making their name in the field as otherwise would be the case. And then there's another issue that's now beginning to take place. Mention was made of the Judge President, Colombo, quite outstanding Judge President. I noticed he's been nominated for Deputy Chief Justice. I won't say more, but all I can say, I know what I would do if I was the President. But I'm saying, Judge President Colombo has recently said, you can't get into courts in the Gauteng High Court in 5-6 years. Can you imagine that? You have a dispute with your fellow directors. right? And it's going to take you 5 or 6 years to resolve it in the High Court, and if the other person has got a lot of money, even if you win, you know, we've got this thing now called the Stalingrad tactic. You know what that is? I mean, you carry on going forever, right, to postpone the inevitable. Now, what Judge Malamba is talking about is people now need to start using alternative dispute resolution, which means people need to be mediating their disputes and going to arbitration. And so, again, the field is getting wider and more nuanced. Because if you don't go to arbitration or mediation, you aren't going to get your dispute settled. And so in the Companies Tribunal, which is where we are, that's part of our role. Part of our role, and we were set up for this purpose, was that people could come to the Companies Tribunal and have their company law disputes mediated or arbitrated in circumstances that they pay nothing. They may pay for their lawyer, but they're not going to pay us. You know, today, if you go to arbitration with all these my retired colleagues, they're earning a fortune. You know, you go to an arbitration, it costs you R1 million, and you're not going to get any change because they're all charging fortunes for the days of the hearing. Here you've got an opportunity through a tribunal set up by the state, particularly again to try to foreshadow the changes in our society. That is, to have a situation where you can come along as a lawyer, you can argue on behalf of a client who possibly doesn't have a big bank balance, and you can argue through either mediation or arbitration. In fact, the Act has now been changed. If they just sign it into law, because it's actually been changed, the Companies Tribunal is the only body that can arbitrate company disputes now. The only body. So that means that here's a whole avenue of dispute resolution which is not used as much as it should be. We aren't used as much as it should be. And young lawyers will be very encouraged to use that body to represent their clients because they can get in within a month rather than in 6 years. And because effectively, other than the fees that they're paying nothing for an arbitration setting. The thrust of my story, and I mustn't overstay my welcome, is this. There is a dynamic to law taking place in South Africa at the moment. We could, of course, move into other areas, but I'm not going to do that. There is hardly an area of law at the moment which, if not subject to change, should be subject to change. Let me give you 2 other illustrations. Not company law, not the Companies Tribunal, not the competition. Take the areas of property and contract law. When you study your LLB degree, you study contract law under what's called Roman Dutch law. Essentially, it's essentially the common law, but that common law was fashioned through, the Dutch, Grotius and Foote, from God knows where back, and in addition to which English. In property law, we have a system of property law which we drum into students about the absolute nature of ownership. That if you're the owner of property, you've got sole claim on it. In other words, if I own a piece of land, I can determine who comes onto my land, and I can determine who should be evicted. Now, if you think about South Africa in both of these areas, take contract law. And I'll give you a simple illustration of a case which was lost. The case started with me, which was finally, only the minority of the Constitutional Court agreed with me, which I still think is a tragedy. But this is where challenges lie. So a group of black franchisees come to my court. And what's happened, they have a lease of premises, and in addition to which they have a franchise agreement, because the franchisor of this business, he owns the property. So basically gives them a franchise agreement for 5 years, or 10 years, on condition that they use his property. So you have to pay rent, and it's a lease for 5 years, renewable for another 5. But they can't exploit the franchise in any other property. It's important to realize this. None of them, as Justice Froneman described in the Constitutional Court in a case called Beedica, which you're very welcome to go and have a look at, Beadica. None of them were what he called sophisticated business people. They weren't at all. So when the 5 years came up, none of them formally extended their lease. They didn't have a formal legal document which says, I invoke my rights to extend the lease for 5 years. But many of them wrote things like, you know, we want to stay for another 5 years, or we'd like to be here for another 5 years and stay in the premises. So, but they didn't do it in a strictly legal way. And the landlord kicked them out. And they lost their franchises. This was a black empowerment initiative, I should say. And so the question was, did our contract law, was it such that we're going to apply the law so strictly that if you didn't formally extend your lease, you'd lose your whole business? Myself, as the High Court judges, Froneman and 2 or 3 others, felt that our law had now reached the point where the notion of what's called pacta sunt servanda, which you all learn in law school, the idea that the contract is sacrosanct and that the terms of the contract are everything, they have to give way to a concept of good faith. If you wish Ubuntu, if you wish some sort of value system of a commune, the majority of the court thought elsewise. And these people lost everything. Now you've got to ask yourself, is that the kind of contract law that you want in a transformed society? And so what I'm trying to say, that law, even though the Constitutional Court put its finger in the dike and refused to change, the majority, there's no question that change will come. Because people like you will basically, who have studied the Constitution and understand the notion of transformation, will start to argue cases which make it more difficult for judges to do. The same is true in property law. It's absurd in a country where 87% of the land was given to what, 7 or 8% of the population, that we hold on to a concept of absolute notions of property, where we can't actually have a situation where property is shared in a way. And there's a huge body of decent literature which argues for a transformed concept of property. And to some extent there, the courts have started to change things. But here too is an area of law which is at the cutting edge. So my message to you, obviously I was trying to focus on company law and to a lesser extent on competition law, but my message was by alluding to 2 other areas of law. This is the time where young people who've got some point of progressive commitment and legal imagination have a real possibility of changing the legal world. And so you shouldn't be despondent. I realize how difficult, I was listening very attentively to issues of mental health and couldn't but agree with you, how difficult this profession is, how sexist it still is. In fact, we sort of are doing better on race than we're doing on gender and things. I might be a controversial proposition, but I really think if you're a black woman, you really have a much more difficult time of it than almost any other group in this country. And that's not to say race has been solved, it hasn't. We still have extraordinary levels of prejudice, both articulate and inarticulate. And we may actually solve the articulate problem, because I see a whole lot of these people want to immigrate to America. My attitude is Mr. Trump, please take it. Right? But my simple proposition is, I understand those challenges, but South Africa is changing, but it won't change, and certainly the legal profession won't change, if people like you don't exploit those possibilities, and they are there. So I just want to, in wishing you well, my sole purpose today was to say there is, carpe diem, seize the day. This is the day in which young people have a serious chance of actually flourishing in this profession because of the dramatic changes taking place in society and the global world as a whole. Please do not scorn that possibility, because with you lies the future of a legitimate legal profession. Thank you.